My supreme namaskarams to Honorable Padmanabh Garu and his daughter Honorable Shailaja Garu and all the students who are attending these classes. Today, I would like to discuss with all of you about technology as a threat to privacy and ethical challenges, and also right of privacy, and what are the information technology intermediary guidelines and digital media ethics code rules 2021, and how the law is dealing with them, and what are the latest cases, and in particular in the light of your competitive exams, which are really very competitive so far as this particular subject is concerned. Very interesting subject. If you put efforts, you can understand it very easily, and also make utilization of your knowledge in your day-to-day life, and see that many people really benefit out of it. We have the Constitution of India and the Information Technology Act 2000. While we were discussing about various fundamental rights, we have had the opportunity to understand about three important fundamental rights, out of which I now include one more and explain to you that these four are controlling our day-to-day life. We know that in part 3 of the Constitution, in the Fundamental Rights, Article 13, it says laws inconsistent with or in derogation of the fundamental rights, so far as they are inconsistent with the provisions of part 3 fundamental rights, they are void. Either the laws which were already there or the laws that may frame in due course of time. This is what we learned. And we also learned that so far as the amendments of the Constitution are concerned, made under Article 368, this Article 13 is not applicable. With this background, let us first understand about Article 14, equality before law. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. So all are equals. The important thing is whether Indians and foreigners are equal or not. This I am saying in order to understand the Information Technology Act in respect of preparation of original content by anybody. What is the difference between a person speaking from some place outside the territory of India and the same person, if he comes into India, whether he is native of or citizen of India or not, if he speaks within the territory of India? That we have to understand. That is to say whether this equal protection clause is applicable to both citizens and not citizens, and also for the acts done in India and outside India. Then we have right to freedom, protection of certain certain rights regarding freedom of speech, etc. We are now concerned with the Article 19A. It says all citizens shall have the right to freedom of speech and expression. Right to freedom of speech and expression. And Article 19(2) says the state can make law and impose reasonable restrictions on the exercise of right conferred by the said subclass, that is Article 19(1)A, in the interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign states, public order, decency or morality, or in relation to contempt of court, defamation, or incitement to an offense. So, in the interest of public and also on certain occasions, we can have rather state can make a law imposing reasonable restrictions. And we are also having Article 19(6). It says nothing in subclass G. What is subclass G? To practice any profession or to carry on any occupation, trade or business. Why we are reading Article 19G? Why? When we speak about the right to freedom of speech and expression, why are we dealing with or discussing about any practice to any profession or to carry on any occupation, trade or business? Because we all are experiencing that our day-to-day life is dealt with by the business apps like WhatsApp, Facebook, and YouTube, OTT. All these are digital inventions. OTT, whatnot. Why I am saying is they are all doing business. They're doing business with a fundamental right. Like any citizen, the business firms or legal entities, they're all having the right to practice any profession or to carry on any occupation, trade or business. So once you understand that under Article 19(1)G, citizens are having right to practice any profession or to carry on any occupation, trade or business, we are also aware that under Article 19(6), in the interest of general public, state can operate, bring into effect the operation of any existing law or can make any other law, keeping reasonable restrictions on the exercise of the right conferred by the said class. Then we are having Article 19 after 1920. 21 says, no person shall be deprived of his life or personal liberty except according to procedure established by law. So procedure shall be fair, reasonable if you make any law. With this background, let us see how this act, that is the Information Technology Intermediary Guidelines and Digital Media Ethics Code, that rules of 2021, is operated or operating. Actually, this law is made to regulate publishers of news and current affairs on digital media and publishers of online curated content on over-the-top OTT platforms from publishing unlawful content. This is very important. So, any publisher of any news or current affairs on digital media and publishers of online in OTT platforms shall be controlled. For what? To publish, from publishing unlawful content. Then, interesting thing is, newspapers, WhatsApp, Facebook apps, and also some business firms, they are claiming that this law is violative of fundamental rights of citizens. Let us now, in the light of these facts, understand a recent case and arguments that have occurred in Madras High Court. In Madras High Court, in one case, rather two cases, two writ petitions are filed by, one is filed by a Karnataka vocalist, T.M. Krishna. This T.M. Krishna is a Karnataka vocalist, and another is, he is having the Digital News Publishers Association, and another is former editor of the Hindu, Mukund Padmanabham. These two persons have filed the writs challenging the constitutional validity of the statutory rules that were notified on February 25. Then the government, central government, filed its counter. Then they are claiming that the right to freedom of speech and expression guaranteed under Article 19 of the Constitution is not absolute right. You are only having freedom of speech and expression. And as we discussed earlier, the state can make use of the existing laws, or can create a law keeping reasonable restrictions on the exercise of this right in the public interest, and also on certain occasions to protect the interest of the sovereignty and integrity of the India, the security of the state, friendly relations, etc., etc. Then important thing is, a common thread that runs across all reasonable restrictions is public interest. And it is beyond any pale of doubt that restrictions may be imposed on freedoms for the interest of the public at large. So we have conceived the fact that restrictions can be imposed, may be imposed rather, on freedoms for the interest of the public at large. Central government is claiming that the rules have been clearly enacted, bona fide for the benefit of the public. And they're also claiming that these rights were framed after holding public consultations with the stakeholders. That is to say, lot of consultations are done. With whom? With business organs like WhatsApp, Facebook, and all the business people who are dealing with these publication of news. Then they are claiming that they are the stakeholders. What about the common citizens? Do us aware about any consultations being done in respect of framing of this law? Definitely, we can say that no discussions are held giving wide publicity about it, or giving a right to opportunity to all citizens to express their views, whatever it is. So far as the central government is concerned, it is saying that after holding public consultations with the stakeholders, the ministry has framed the rules, keeping in view the significant expansion of the online intermediary ecosystem, growth of online social media platforms. And the third important thing is their influencing capabilities. These three aspects: expansion of the online intermediary ecosystem, growth of online social media platforms, and their influencing capabilities. Rules had been brought in to provide an institutional framework for digital media and OTT platforms. So digital media and OTT platforms, they must be allowed to do only business within the framework of law. They shall not publish unlawful content. So for that, an institutional framework is required. And the central government says that these rules that are framed to regulate unlawful content is the institutional framework for digital media and OTT platforms. So with this background, we also have to understand certain more cases, especially in the light of the fact that the Honorable Supreme Court refused to accept the request of the central government to stay the proceedings in all the high courts where several petitions are filed questioning the validity and constitutionality of these rules. So different states, different writ petitions are filed, and the Honorable High Courts are considering to pass interim orders. I came to know that in Bombay, some of the rules are stayed. Of course, the stay order that is granted by the Bombay High Court is, we can say, applicable in the territory of the Maharashtra state. In Madras, that is Chennai, that is Tamil Nadu, no stay is granted. I came to know in many other places, in many other states, writ petitions are filed. So with this background, let us see how the Information Technology Rules 2021 were framed, and what is the source of law power for making these rules. These rules are secondary or subordinate legislation that suppresses the India's intermediary guidelines rules 2011. So in 2011, intermediary rules, guidelines rules were framed. Then the 2021 rules have stemmed from section 87 of the Information Technology Act 2000. You know that we are having the Information Technology Act 2000, and in order to give legal recognition for transactions carried out by means of electrical data interchange and other means of electric communication commonly referred to as electronic commerce. This particular the Information Technology Act 2000 is framed. In this act, section 87 is very important. You can note that section 87 says that there is power to the central government by notification in the official gazette and in the electronic gazette to make rules to carry out the provisions of the act. So section 87 is giving power to central government to make rules and publish in official gazette also in order to carry out the provisions of the Information Technology Act 2000. With this power, by stemming out the earlier 2011 rules, that is intermediary guidelines, a draft notification is prepared. It is a combination of the draft intermediate rules 2018 and the OTT regulation and the code of ethics for digital media. Three things clubbed together, these rules are framed. One is intermediary rules 2018 and another is OTT regulation and third one is code of ethics for digital media. So these rules are made by the central government of India along with the Ministry of Electronics and Information Technology, which we call as MeitY, and the Ministry of Information and Broadcasting, MIB. They coordinated in the development of the rules. We are having the history of it. Actually, to replace 2011 rules, guideline rules 2018 is framed, and thereafter, as I said, in order to prevent the misuse of social media platforms and to provide security to the users, these three are clubbed. That is three rules I stated earlier. That is OTT regulation and the code of ethics for digital media and 2018 intermediate rules. They're clubbed and the rules are made. We are aware that a social media a notice was issued to social media WhatsApp in July 2018, warning it against helping to spread fake news and look on as a mute spectator. WhatsApp says our CJ app, if anybody sends some information, we are not liable for it, even if it is fake news. Then a notice is given by central government giving a warning in July 2018 that you have helped to spread fake news and you look as a mute spectator. Then you know about the Prajwala case. The Honorable Supreme Court India on 11th December 2018 observed that there must be some necessary guidelines and implement those guidelines within 2 weeks. For what? To eliminate child pornography, rape and gang rape imageries, videos and sites in content hosting platforms and other applications. Thereafter, a parliamentary report also is laid in 2020, which studied the effect of pornography on children. Then there was discussion of the rules in open house on 5th January 2019 by the government. Then counter comments also received. Then the center informed on 21 September 2019 to the bench of the Honorable High Court of Chennai about these rules. Then Facebook app business organization had written a plea to transfer the matter to the Supreme Court. So that went on. Then thereafter, these laws are made, rules are made. Main important thing that is focusing is Rule 4.2. The Rule 4.2 says identification of the first originator of the information. How to identify the first originator of the information? This rule says the extent of the first originator is limited to India. It also said, provided further, that where the first originator of any information on the computer resource of an intermediary is located outside the territory of India, the first originator of that information within the territory of India shall be deemed to be the first originator of the information. This is important. So suppose one information or fake news or content is originated somewhere outside the territory of India, then for the purpose of India, as per these rules, that person cannot be treated as first originator. And who is treated as the first originator of that information within the territory of India, he shall be deemed to the first originator of the information. That is to say, suppose from outside India, some information is brought or loaded in a particular digital platform within the territory of India, then that person who first received that information is treated as the originator of that information within the territory of India. So here comes different problems. Then what people say that this is violative of the right to privacy of the individual and particularly right to free of speech. This amounts to a restriction of free speech. Requirements such as automatic identification and removal of the content and lack of elaboration on how the 5 million users will be calculated. How to implement? How to identify automatic identification, how it can be done? How to remove the content? And when there are, at that time in 2018, nearly 5 million users were calculated as the persons who were using these platforms. So with this, what is happening is, when Supreme Court refused to stay all the matters that are pending in Honorable High Courts, and in Supreme Court the matter is pending, the problem is there must be a clear discussion in respect of the rules and guidelines, more particularly about appointment of chief compliance officer, a nodal contact person, and a redressal grievance officer. All these things are necessary for what? In order to prevent all these platforms from publishing unlawful content. then what to be done? Certain guidelines or rules are framed, especially for implementation of these rules. So far as the central government is concerned, it says that the law in India, and more particularly the government, fully recognizes and respects the right of privacy as pronounced by the Honorable Supreme Court of India. So, while we are accepting that there is a right of privacy to all, we are also claiming that privacy is the core element of an individual existence. And in the light of this, the new IT rule seeks information only on a message that is already in circulation that resulted in an offense. So what we say is, we are not preventing anybody from bringing into the fake news into digital platform. We are only after the message that is already in circulation. If it resulted into an offense, then we are stopping it. We are preventing from publishing and continuing publishing of it. So our government also in United States also clarified that new IT rules are designed to empower ordinary users of social media. So I am now, suppose I take a case of a normal citizen. He is targeted by some people and send a fake news. Then that ordinary user of social media has no power to fight with the media. So to empower him, these rules are made. That too, after consultation, broad consultation with the civil society and the stakeholders. So we have to keep in mind that these rules which have come into effect from May 26 of 2021 really empowering ordinary users of social media or violating the right to privacy. To keep this, we must keep in mind that the victims of abuse at social media platforms shall have a forum for redressal of their grievances. So these rules have come into force, and the concerns alleging potential implications for freedom of expression that the new IT rules will entail is claimed as highly misplaced. India's democratic credentials are well recognized. The right to freedom of speech and expression is guaranteed under the Indian Constitution. We are having independent judiciary and a robust media and these are part of India's democratic structure. Suppose a message already in public circulation is giving rise to violence, impinging on the unity and integrity of India, or depicting a woman in a bad light, or sexual abuse of a child, and when no other intrusive options are working, only then the significant social media intermediary will be required to disclose as to who started the message. Suppose if the message is there in circulation, then who started it at first? Which media is intermediary? And that has to tell and disclose about who started the message. Then social media platforms, number of social media platforms which use end-to-end encrypted technology to ensure user privacy are arguing that they will have to read, track and trace all user messages in order to trace the first originator of the text that are offensive. What these people are telling is, we are having a system of end-to-end encrypted technology. That is to ensure the privacy of that person who is using that particular app. If you ask us to locate and trace the first user, then the app authorities